Thank you, Tammy, and good afternoon to you all. The subject today, as you already are aware, is subrogation. For those of you who really aren't familiar with this topic, let me give you a quick definition of what subrogation is. Basically, subrogation is the process by which you can recover workers' compensation benefits which have been paid to your employer, your employee, or an employee of your insured, depending on whether you're an employer or the carrier, or another party, we call that the third-party defendant, has been responsible for the accident. You'll see on the screen a couple of examples of that. Your salesman is out driving on a sales call and gets rear-ended while he's driving off to the site. An office worker walking through the lobby slips and falls on some water. A construction site worker falls into a concealed hole, or a secretary is injured when a defective chair collapses. In all of those cases, the common element is that the injury, though the person was on the job, was actually caused by somebody else. And it's that somebody else that we're going to be talking about suing, going after, recovering money from today. The first thing you have to do in order to make that happen is to identify those claims which have subrogation potential. And we can do that in a couple of different ways, and I'll be talking about them in a moment. The first and best way is to identify those claims yourself, to see the claim coming in the door and say, I see that. That's a case that has subrogation potential. Those cases tend to fall into a couple of general categories. The first category that you want to look for are accidents which occur away from the employer's premises. By definition, in order to have a subrogatable claim, you've got to have somebody else involved. That means the most likely to occur when your employee is, out in the world. The classic example, obviously, is an automobile accident, a slip and fall in a common area, or a construction site accident. The other things that often lead to subrogatable incidents are injuries caused by defective products. A ladder collapses, a piece of equipment in a factory malfunctions. Or, and this is less common, but it's an obvious case, accidents caused by assaults by third persons. Somebody walks into the 7-Eleven and punches your clerk in the nose. In each of those cases, you've got somebody who, at least theoretically, you can sue. Another area that you can pursue subrogation in is what's called an aggravation. The situation here arises most commonly where you've got an individual who's been injured in an industrial injury, and let's say he's driving off to a medical appointment. And while he's on the way to that medical appointment, he's involved in an accident. Now, the auto accident that he's involved in while he's going to the medical appointment is itself a non-industrial accident. But it has the potential to aggravate the injuries he's already suffered. And to the extent you can establish that aggravation, you can sue that other driver who caused the accident and recover the money. Now, the problem you've got there is that you can only recover the aggravation. Obviously, you can't recover for the injuries the employee already had suffered. So you've got a somewhat difficult proof problem here. As a practical matter, those injuries are usually limited to temporary disability and medical benefits because, of course, those aren't apportioned. And permanent disability benefits traditionally can't be recovered because they're going to be apportioned in any event, so the aggravation is going to go right out of the equation. Now, if you have a question about whether or not you've got a subrogatable claim, and you don't know whether you're really looking at something that will work, by all means, give us a call. At the end of this presentation, there will be phone numbers for myself. I'm the attorney with subrogation in Anaheim, or you can talk to our subrogation attorney here in Ontario. That's Peter Fitzpatrick, and either one of us will be happy to talk to you about this. Let's suppose, moving on for a second, that this is a claim that you haven't identified yourself as having subrogation potential. Are there other ways you can find out about it? The answer is yes, you can. And the first way, the way it's supposed to happen anyway, is that you're supposed to be notified by the injured employee himself or herself. Labor Code Section 3853 says quite explicitly that a notice of a pending action, that's a document that has to be filed in Superior Court, and a copy of the employee's complaint has to be provided to the employer. Now, note that it's got to go to the employer, not necessarily to the carrier. That means your employer's got to watch for that to come in and tell you about it. There's a caveat there, as you can see from the screen. Although the statute says the employee has got to provide a copy of the complaint, it's been interpreted, as so many Labor Code sections have been, and the interpretation is that almost any informal notice, a letter to the employer, is good enough. So once again, your employer has to be looking for this, and they've got to be notifying you about it when it happens. Now, a second caveat, and again you'll see it on the screen, is that this obligation applies only to filing the action. Most of these cases are negotiated before the action is ever filed, and the employee has absolutely no obligation to notify the employer that he's trying to settle the case, which, as you can see, makes it all the more important that you're identifying these cases by yourself. The other problem here, you need to be aware of it, is that you shouldn't really count on getting that notice. Even though 3853 says that the employee is supposed to do so, many personal injury attorneys, who frankly don't have much experience with workers' compensation subrogation, don't know the statute even exists, and among those who do, there's a tendency to ignore it, hoping that the employer simply will go away. Okay, you haven't identified it yourself, the employer hasn't told, or the employee hasn't told you about it. Is there any other way? Well, yes, there is. You can also find out because sometimes that third party will come to you. What I mean by that is you and the employer, and when I say you, I'm referring to claims adjusters and insurance carriers, because I'm assuming that's who are most of the folks who I'm talking to today, have a monopoly on certain classes of information. As the carrier, you pretty much got a monopoly on the medical records. And your employer certainly has a monopoly on the wage income that the employee has been receiving, and both of those are critical components to the third-party case, which means that at some point in that case, you or your employer or both are likely to be getting subpoenas or demands for inspection from that third-party defendant, demanding information he needs in his case. And when those come in, those should be a red flag to you that there's a third-party case out there. Now, I understand you get subpoenas all the time, so it may not be obvious. What you're looking for is a subpoena which, unlike all of the subpoenas you're getting in your workers' comp case, has across the top of the phrase, Superior Court of the State of California. The subpoenas in your workers' comp case obviously say Workers' Compensation Appeals Board. If it's a Superior Court subpoena, it means something else is going on. Another way to find out, and this is one of the best ways, is that your workers' compensation defense attorney ought to be asking these questions in the workers' compensation deposition. It just ought to be a standard form of questioning. Have you filed a subrogation claim? Do you expect to do it? Finally, this is a little unusual, but it does come up. When you're reviewing medical reports, those medical reports are going to be sent out by the treating physician to a variety of people. It'll go to the applicant's attorney, it may go to the defense attorney, a copy may come to you. But if you see a law firm on that medical report you don't recognize, the odds are that's the applicant's third-party attorney. He's getting copies of those reports too, and if you see that unfamiliar attorney, watch out for it. Okay, moving along yet again. One way or the other, we've identified this case as something that has subrogation potential. What are we going to do next? The first thing we're going to have to do is make sure that this isn't one of a class of cases which, although they look like they have subrogation potential, really don't. And there are several important classes that come up with some frequency. The first of these, alas, is medical malpractice. Under what's laughingly called the micro-legislation, medical malpractice has been restricted very strongly. And one of the ways it's been restricted is to bar workers' compensation subrogation cases. So even though you might have a claim when a doctor commits malpractice on one of your employees, you don't have subrogation. Now, you have to be a little careful here because not everything that happens to an applicant, even something that happens to an applicant in a hospital, is medical malpractice. If the applicant falls out of bed, in one of my cases, the x-ray technician dropped an x-ray machine on him. Those things are in hospitals, but they're not technically medical malpractice. Another example are situations where the injury, though it happens in a hospital, is due to a defective product. Some years ago, there was an enormous set of litigation over defective heart valves. There's also defective litigation over defective hip joints, knee joints. Those litigations, even though they involve medical practitioners, still have subrogation potential because you're not suing the doctor, you're suing the provider of the medical equipment. Let's talk about another exception, and this is a big one. This is the general special employer exception. And move right on here because I went by one. Let's say you're an employment agency You send your employee off to work in a factory, and while he's working in that factory, one of those factory workers commits negligence, runs him down with the forklift. That looks like it ought to be a third-party case. No, it's not. Because what you've got is a general special situation. Both the employment agency that sent the employee and the company that's using him are his employees, or his employers, pardon me. And because of that, they're both covered by the exclusive remedy rule of the workers' compensation laws, and there's no subrogation possible. Another area, which looks like it might be a subrogatable claim but isn't, falls into the uninsured, underinsured motorist situation. Here, your employee goes out and gets in a car accident, but instead of suing the other party, who, for example, may be uninsured, he decides to pursue a claim against his own insurance policy, either his own personal policy or the employer's policy if he's an additional insured under that. In either case, because this is what is known as a first-party claim, that is to say the insured under the policy is trying to recover under his own policy, there is no subrogation. The next set of things that can cause you a problem are contractual language situations. How does that come up? Well, in many cases, your employee, your employer actually, is going to have entered into a contract with the party who would otherwise be the third-party defendant. This commonly comes up in construction cases where a subcontractor has entered into a contract with a contractor, or in a landlord-tenant situation where your company is the tenant in a building owned by a property manager, and the employee is then injured in that building. There will be pre-existing contracts governing those parties' relationships, and you have to look at those contracts very carefully. Pardon me, because they may have three kinds of clauses in them which can strongly affect your ability to conduct subrogation. The first is straightforwardly a no subrogation clause. Obviously, if your employer has given that kind of a clause in the contract to the other side, you're out of luck. The second kind of clause is an indemnity clause. Here, there's no specific bar in subrogation, but your employer may have said to the party with whom he's contracting, and this is very common in construction situations, if something goes wrong, I promise to take responsibility for it, even if maybe it's partially your fault. This is a rather complex area of law because you've got to examine each indemnity clause to determine what the specific use of the clause is and what specific level of negligence applies. All you can really do here is see if the clause exists. If it does, you really need legal advice. By the way, before I pass on that issue, sometimes these indemnity clauses can work in your favor. That is to say, it's possible that that third-party defendant has issued an indemnity clause in favor of your employer. And if that's the case, it gives you an extra string in your bow because you can take advantage of that clause as well. Third and finally, there are attorney's fee clauses. Clauses which say the prevailing party in a lawsuit between us is entitled to attorney's fees. Those clauses apply to the workers' compensation carrier as well because, in effect, he's standing in the shoes of that employer and employee. Those attorney's fee clauses can cut both ways. If you were to file a subrogation case in a situation where a clause existed and lose, you'd end up having to pay attorney's fees. On the other hand, if you're prevailing in that case and you've asserted the attorney's fee clause by virtue of the contractual provision, you may be able to get your attorney's fees as well. So as I say, it works both ways. The final one that you have to be careful of, and this is a particularly nasty one, is our friend CIGA, California Insurance Guarantee Association. Now, how do they get in this picture? Let's say you've got a good subrogation claim going. You found a case that looks like it has merit. The third-party defendant has a liability insurance carrier with a big policy. You're going to recover. Except, halfway through the case, that liability insurance carrier goes belly up. California Insurance Guarantee Association steps in, and unfortunately, when they do so, your case goes along with them. Because under CIGA's governing regulations, the claims by workers' compensation carriers for subrogation are not, quote, covered claims. And because they're not, CIGA has no obligation to reimburse you. And because CIGA doesn't have any obligation and it's standing in for the liability insurance carrier, the third-party defendant doesn't have any obligation either. You're just out of luck. Okay, let's move along again. We found a claim that we think has subrogation potential. It doesn't fall into one of these classes where for some reason or other we can't proceed. What do we have to do next? The next step is to preserve our rights. And the most important thing there concerns the statute of limitations. Now, in California, the statute of limitations for personal injury actions, and obviously that's what we're talking about here, is 2 years. And what's important about that is that it's something we have to really take seriously. In workers' compensation practice, we have statutes of limitation too. But the truth of the matter is we really don't pay much attention to them most of the time because the number of occasions when they actually apply, when the courts haven't just bent the rules to make them go away, are really quite small. In Superior Court, in contrast, the rule is entirely different. Statutes of limitation are taken very seriously indeed. You blow the statute of limitations on a civil case by a single day, and it's over. Now, I will say there are some games we can play sometimes if you've only missed the statute by a day or two. But really, you must be very careful of this. Now, there are some things to get around the statute of limitations, and most important of them is what's called tolling. Not uncommonly, your injured employee will have filed a lawsuit himself, because after all, he's trying to recover his claim. And if he's done so, his filing of the lawsuit tolls the statute for your claim so long as his action is pending. Now, this also works in reverse, by the way. If, for example, you were to file an independent subrogation action before the employee filed his, and he blew the statute, he could tag along with you as well. So it works both ways. Now, what is important to remember here is that it's only filing an action which stops the statute. I've talked to too many claims adjusters who tell me, oh, I've given notice to the other side. I sent them a letter. That letter won't do it. Unless you've actually got a complaint filed with the Superior Court, the statute is still running, and if it runs, you're out of luck. Now, in addition to statute of limitations, there's something else you sometimes have to keep in mind. And these are what are called government claim filing statutes. In effect, they're special statutes of limitation just for governmental entities, and they're much shorter than statutes of limitation. The claim filing statute limit is 6 months. That is to say, within 6 months of the date of injury, you've got to file a claim with the government entity against whom you're going to file your lawsuit. Now, as I see on the screen, in theory, you've got an additional 6 months for a total of 1 year. But as a practical matter, that latter period really doesn't count for much. The problem is, the way to take advantage of the second 6 months is to file a petition with the Superior Court in which you walk into the court and basically beg the judge to let you out from under the claim filing statute by offering some very good reason. You've got to show good cause. And that's hard because the Superior Court judges don't like these claims. They love to turn them down. And if you've blown the 6-month period by more than a couple of months, you're probably not going to get that claim passed, even if you've got a good excuse. So please, get them in on time. And in addition to getting them in on time, it's critical, got one more thing to say. Once you've filed the claim, there's another period that starts up. And that's a 6-month period from the date that the claim is denied. What happens here is you submit your claim to the government entity, and one of two things will happen. They'll either send you back a letter saying your claim is denied, in which case your 6-month period starts, and you've got that length of time to file your action, or they can simply ignore you, which frankly is much more common. And 45 days after you submitted your claim, it's deemed denied. It's denied even if they haven't said anything, and that's when your 6-month period starts. So once again, you've got to be a little careful. Then in addition to getting the dates right, which is complex enough, you got to get the claim right. That is to say, the claim when you submit it to the governmental entity has to specifically indicate what it is you want, and it's got to go to exactly the right place. Now, it's often not easy to figure out which governmental entity you're sending this to, or for that matter, if you know who it is, where to send it. You have two advantages here if you're having trouble figuring this out. For state agencies, the California Secretary of State maintains what's called a roster of public agencies. You can get a hold of a copy of this from the Secretary of State, and you can find out what the exact name is of the entity that you want to sue and where you have to send the notice. And for county entities, for entities in a county, even if they're not specifically with the county clerk will have a similar roster. So if you're going after a local agency and you're not sure how to go about filing a claim against it, that's where you have to go. Finally, as you see on the screen, you have to be very careful to set forth the facts, because if you don't set forth the facts, you don't set forth your claim, it's going to be barred. Now, let's suppose you've managed in all this complexity not to get your claim in on time. Are you out of luck? Not necessarily, because just as the filing by the employee told the statute of limitations, the filing of a claim by the employee tolls the claim filing statute. So if your employee has filed a claim to start that process, you can piggyback on it. In this particular case, however, the reverse isn't necessarily true, because the employee can't piggyback on your claim unless your claim includes his damages. That is to say, when you file a claim with the agency, you say, not only do I want to recover my damages, I want to recover his as well. Believe it or not, you can do that, and we'll talk about it later. And you want to say that because you want to make sure that you can assert those damages down the road. Okay. Now, we've moved on past identifying the claim, past figuring out whether it's really subrogatable, and we've protected the statute, or we think we can. We know what the deadlines are. We're ready to go. What do we do next? The next thing we have to do is investigate. We have to get the facts that we need in order to make sure we can actually make this claim work. And the most important thing I can tell you about that is start early. Yes, you've got a 2-year statute of limitations, but if you wait 2 years to start investigating this claim, you made a very serious mistake. You need to locate witnesses, you need to preserve evidence, and you need to do that now. It's particularly important for a variety of reasons that you get out early and talk to witnesses. For a couple of reasons. First, the witnesses may disappear, particularly in construction cases. Once that construction site is completed and those subcontractors are gone, tracking down the witnesses who have observed that construction accident can be an impossible job. Secondly, of course, there's the problem that if you wait too long, witnesses can forget stuff. They may have known the details of an incident the day it happened. A week, a month, a year later, don't count on it. And finally, there's a psychological aspect to this. If you're the first person to talk to a witness and you've got a skillful investigator asking the questions, you can often get that witness to remember things in a favorable way. The reason I say that, the first statement that a witness makes often is what the witness then remembers. Remember, witnesses' memories aren't tape recorders. They're very flexible. And once a witness has given a statement, particularly if it's a statement favorable to you, what you often hear is the next time that witness is asked to recount the events, they recount the statement they've given, sometimes almost verbatim. So it's important. Get your people out there early, talk to these witnesses, get your spin on the facts. Okay, let's talk about some specific areas of investigation and specific types of claims. First, motor vehicle accidents. Some things here are obvious. The first and most important thing you want to get, obviously, is the traffic collision report. And here, there's something in that report that isn't often caught. You really want to. The traffic collision report will indicate whether there are photographs taken at the scene. Now, the report itself is filed away, and you can get those reports a long time later. But those photographs have a tendency to disappear because they're often not kept with the report. They're just out there somewhere. And they're often critical. They're the one set of photographs that actually depicts what went on at the scene of the accident right after it occurred. If you see them, make sure you get them. The next thing you want to get are the 9/11 records. And here again, these are ephemeral. These are the records that were generated when whoever saw the accident called it into the police and the police responded. Those are witness statements and they can be very important. But unlike the traffic collision report, these 9/11 recordings tend to be recorded over. So if you don't get to them in the first 30 to 60 days, they're probably gone. Next, You want to get photographs of the accident scene. You want to get photographs of all of the damaged vehicles, and I mean all of the damaged vehicles, not just your own. You want repair estimates and invoices of those vehicles so you can establish the extent of the damages. In commercial cases particularly, you want to see if there are in-vehicle recorders. Commercial trucks commonly have GPS, computer speed records. Even automobiles today have computer and data chips that can give you a great deal of information. But particularly in the case of automobiles, if you're going to get that data, you've got to get it immediately, because this data, because it's in such small computer chips, generally is only saved for a short period. It's generally based upon the number of times the car engine is started. So if it's started more than 4 or 5 times, the odds are very good you're not going to be able to get it done. Okay, let's move on. Another thing you're going to want to get are liability insurance policies. You're going to want to confirm the existence of liability coverage, and the critical reason for that is because under the statute, if the employee doesn't have liability in coverage, all the non-economic damages that you might recover go away. Now, workers' compensation benefits are economic damages, but you're also going to be trying to recover the employee's pain and suffering, and that can be at risk. Finally, you want to preserve the vehicles themselves if it's a catastrophic crash. In a really bad accident, you're going to want an accident reconstructionist to tell you what's going on, and the only way he's going to be able to do that is if he's got the vehicles to look at himself. Other areas of importance, and I'm going to go over them rather quickly, are product defect cases, which I don't have time for because my assistant here is telling me I'm running out of time. Here are the critical issues concern securing the evidence, securing the machines, securing the documents concerning the machines. And the second category that you're going to often run into are premises cases. And here, one of the things that's really critical is securing surveillance video, because once again, this is ephemeral. If you're going to get it, you're going to have to get it before somebody records over it. Finally, construction accidents, we talked about those earlier. The most important thing is to talk to your witnesses early. Once again, you want all the records you can get, safety records, contracts, whatever is going on out at that site that's been committed to paper. Now, I know I went through that too quickly, but bear with me, because there are other things we have to talk about. Let's say you're doing your investigation, you're getting your records, you've got your subrogatable claim. Now what? Now you've got to notify the defendant of the existence of the claim, and this is critical. Remember I said earlier that the employee doesn't have to tell you whether or not he's trying to settle his case. If the employee succeeds in doing that, if he settles the case before you give a notice to the third-party defendant, you just lost your case against the third-party defendant. Because if he settles before he knows you've got a claim, it's gone. So you have to assert that claim before it happens. Now, what happens if you do give the notice is that now the defendant's on notice. If he settles with that third party, with the employee without telling you, now he's exposed to the potential of a double recovery. And that's going to prevent him from doing it, I guarantee you. Now here, unlike the statute of limitations, a simple letter will do. Just put him on notice. Tell him, we've got a subrogation claim, take care of it. Let's say you didn't give notice. Are you out of luck? Not necessarily, because what the statute says is that the defendant has to know about it, and that's the way the courts have interpreted it. So if you can establish that the third-party defendant knew about your interest, even if you didn't think to tell him, he's still on the hook. So if you're in this situation, the first thing you want to do is subpoena the records from the liability insurance carrier for the third-party defendant, because almost certainly somewhere in there it's going to indicate that this was an industrial injury, that he was on the job. And if that happens, that's enough to establish knowledge. Okay. You're going to subrogate the case. How do we do it? You got a couple of different ways to do it. The first way, and the way in which a lot of subrogation professionals think they like to do it, that you will see I don't agree, is by filing what's called a notice of lien. This is a procedure in which you simply file a notice with the court in which the employee's action is pending, saying, I have a subrogation interest here. I've got workers' compensation benefits I want to recover. I want to get paid out of the judgment. Obviously, it's an inexpensive procedure, and it can be filed at any time in the lawsuit prior to the payment of the judgment by the defendant. So you've got a lot of time to do it. Now, the effect of that is that it places the parties on notice that you've got a claim. In theory, heavy emphasis here on in theory, it requires the defendant to pay the lien out of any judgment which it is obligated to pay. And because you're not a party to the case, there are certain kinds of discovery in the case which parties pass back and forth. Interrogatories, requests for admissions, requests for production of documents that you don't have to participate in. You do obviously still have to respond to subpoenas and to depositions as a non-party, but the other things no. And it's important to remember, if you elect to go this way, the parties who are in the lawsuit can't drag you in. They can't force you to become a party against your will. Now, there are also some things you can't do. You can't conduct discovery. You don't get any of the pleadings or discovery generated by other parties. You have no right to notice of court hearings, and you can't participate in them if you do get notice, and you can't participate in the trial. And those things can be real disadvantages. Now, the advantages, I say, is that it supposedly allows you to recover the benefits at low cost. There are a number of reasons why I think that is a really bad idea, and let me explain them to you now. First, if all you are is a lien claimant, you're at risk of being settled around. What that means is this. That notice of lien only applies to a judgment. Most personal injury cases actually settle. They don't go to judgment at all. And if in that settlement, the employee and the third-party defendant simply say, you know what, we're only going to settle the employee's damages. We're not going to settle the workers' compensation claim. Whatever monies the employee gets are his. Now, you might say, well, why would the third-party defendant do that? That's kind of foolish. That leaves them liable to our claim. We can sue them. And, in fact, you can. But you need to understand how that happens, because these settle-around settlements always occur the same way. The day before trial, maybe the day of trial, the third-party defendant and the employee contact you as the workers' comp carrier and say, guess what? We've settled around you. You now have, what, a day, 2 days maybe if you're lucky, to send your attorney down to court, file your complaint in intervention, walk into court and say to the judge, Your Honor, we just became a party to this case. Can we continue the trial? And the answer to that question invariably is going to be no, which means you are now faced with a very unpalatable situation. You can either try a case in which you had no participation, have no witnesses, have conducted no discovery on zero notice, or you can walk away with nothing. That's not a place you want to be. Secondly, let's suppose that the trial is conducted. You're exposed to risk of employer negligence. After all, just because you're not a party to the lawsuit doesn't mean that your employer's negligence can't be addressed in that trial. And if that happens, if there is negligence conducted, two things happen. First, it can have a very dramatic effect upon your ability to recover your lien, probably blow it away. And secondly, because that issue has been resolved in the Superior Court, even if you weren't there, so long as you got notice that it was going to be addressed in the court, that ruling is also going to govern any credit proceedings which follow in the Workers' Compensation Appeals Board, so it's going to hurt you twice. And finally, thirdly, let's say everything goes right. The case goes to trial, and there is a judgment, and either there isn't any employer negligence or not much, and you're looking to get some money out of it, you're only going to get a fraction of the money you think you're going to get, because you're going to end up paying common fund attorney's fees to the applicant's attorney. The way this works is very simple, however unfortunate. Because this is a common fund, that is to say the applicant's attorney has generated money both for his own client and for you, the court says you've got to pay a share of the attorney's fees as well. And that share is going to be determined by the fee which the applicant agreed to pay. So if he's agreed to pay 33% or 40% or 50%, so are you. And you're also paying a pro rata share of the costs. So even though you filed this lien to get your money back, your best case scenario is that you're going to pay a whole lot of money to somebody else to get it, almost certainly a great deal more than you would have paid your own attorney if you got it. Remember what I said earlier? The great benefit of filing a notice of lien is that it's supposed to be low cost. Well, it is. but it's only low cost if you lose. I recommend an entirely different approach. I think that you've got to be aggressive in these cases. If a subrogation case is worth pursuing at all, you want your attorney handling that case to have the same proactive approach you'd expect from your workers' comp defense attorney. If he's not giving you that, if he's filing liens, he's not doing his job for you. I will say one thing. There are some cases in which you've got to file a notice of lien because you can't do anything else. We talked about no subrogation clauses a minute ago. In that situation, you can't subrogate, but the courts have said you can file a lien. So in that one case alone, maybe this is an appropriate procedure. What do I suggest you do? You file your own complaint, either a complaint and intervention or an independent action. Basically, a complaint and intervention is just like any other lawsuit. Your employer has filed a complaint, you file a complaint in that action, you act as a party. But the procedure is just like filing any other complaint. You go down to the court, you file your paperwork, you pay the money, you're a party. Now, the court will customarily require you to file a petition to intervene or a motion to intervene, but you've got an absolute right to do so. It can't be turned down. And this complaint and intervention can be filed, at least in theory, at any time the employee's action is pending. As a practical matter, you don't want to wait to the last second, but in theory you could. Now, the effect of that filing, you've got all the rights of the party. You can conduct discovery, you can participate in the trial, you can conduct a trial if the employee decides to settle around you. And the important thing here is, if you've participated in that lawsuit, if you've gotten yourself in a position where you could conduct a trial, that by itself is the best guarantee that you're not, in fact, going to be settled around. So, the other thing that's useful here is that if you've participated in the trial, if you've engaged in discovery, if the employee at some later point, for example, in the credit petition proceeding, decides that he is going to raise the comparative negligence issue, you've got the same discovery he is, you've got a way to fend that off. So you've got your verdict. What happens? The way the verdict is determined is based on the employee's damages. But you've got a first right of recovery. That means if you've got a lien, in this case you've got a judgment as well, you get paid first before the employee, before his attorney, before anybody. And if that means, after you've recovered your lien monies, your workers' compensation benefit monies, that there isn't enough money for the applicant's attorney or the applicant, that's just too bad. You get it anyway. Now, in some cases, the injured employee himself won't file a claim at all, either because he's happy with his workers' comp benefits or increasingly because he can't find an attorney who'll take the case. After all, if you're a personal injury attorney and you find out there's a big workers' comp lien, why would you want to work and do all that effort so that somebody else can collect their money? So often, the attorney for the workers' comp carrier is in fact the only attorney in the case. Now, the independent action is just exactly the same as the complaint and intervention. You go down to the court, you file your paperwork, you've got 2 years from the date of injury to do it, and once you filed your complaint, you're a party just as you would be if you were involved in a complaint and intervention. Now, the recoverable amounts are a little different. I want to talk about that for a second. As before, the measure of damages is the employee's damages, not the workers' comp benefits. I've got an example I want to show you about that later, but it's important to know. And secondly, the action is tried just as though the employee was still the plaintiff, even though you're the workers' comp carrier, and the judgment that's entered is the same judgment which would be entered if the employee was a party. That means it includes not only your workers' comp benefits, it includes the employee's wage loss, it includes the employee's pain and suffering as well. And that's important because out of that judgment, you can get some things you could never get any other way. The statute which decides how these monies are supposed to be paid out lists the order of payment as follows. First, the employer's attorney's fees and litigation expenses. What I hear you say, attorney's fees and litigation expenses? That's right. In this situation, you can not only recover your lien, your workers' comp benefits, you can recover the costs that you incurred to get the money back. Secondly, you get your loan liens. And third, if, as is often the case, there's money left over, because this was, after all, the employee's case, that money goes to the employee himself, which, by the way, is also a benefit for you because you're going to take a credit in the amount of whatever he gets. So for a lot of reasons, this is a very desirable solution. Now, let's talk about what we're going to do next. We've got a verdict, but in our case, our employer's negligent. How does that affect how much money you're going to get? It does because the employer negligence reduces the amount of money that you can get back, and it does that by establishing what's called a threshold. Let me give you an example to show you how this works. Let's say we've got a case in which the employee's claim is worth $500,000, and you've paid $100,000 in benefits. To determine that threshold, what you have to do is multiply the employer's comparative negligence by the total value of the claim. So let's say we've got a situation where neither the employee nor the employer is comparatively negligent. The defendant did it all. Then it's really easy. The verdict for the employee is, as before, $500,000. The comparative negligence is 0. The employee recovers $100,000. Pardon me, the employer recovers $100,000. That comes out of the employee's recovery. He gets $400,000. The defendant pays a total of $500,000. Let's change the example a little. Let's make it slightly more complicated. Let's say that your employer is a little negligent. The employee's still not so much. The defendant's now 90%, the employer's 10%. The verdict's still $500,000. But now, to determine the employer's recovery, we have to take that 10% employer negligence. We have to multiply it times the value of the case, $500,000, and that gives us $50,000. That's what we call the threshold. That's the amount of money the employer had to pay before his subrogation rights kicked in. So we subtract that from what he's actually paid, $100,000, and the employer recovers $50,000. The employee's recovery, however, is still only $400,000 because because those workers' compensation benefits are still deducted from his recovery. The only difference here is that instead of the employer getting the whole, $50,000 goes to the employer, and $50,000 is a savings to the defendant who doesn't have to pay it. Let's change the example again. Now, here the example is a little extreme. You notice I've got the employee being 90% negligent, the defendant 10%, and the employer 0%. As a practical matter, if you had an employee who was 90% negligent, you probably have a defense case. But I want to show an interesting point here. In this case, though the value of the case is still $500,000, the employee's verdict, the amount he can recover, is only $50,000 because he's 90% negligent. Now the employer's threshold is still 0 because there's no employer negligence. How much can the employer recover? He can only recover $50,000. He can't get the whole 100 even though he wasn't negligent. And the reason for that, as I said earlier, is because the value of the case is based on the employee's damages, not the employer's workers' compensation benefits. This is an issue which even some workers' comp subrogation specialists don't seem to understand. The measure of damages in a workers' compensation case is always the employee's damages, not the workers' comp benefits themselves. Now, you'll notice, by the way, let me go back here a second, we had a negligent employee here. Ordinarily, when a negligent employee exists, the employer is liable for that under a doctrine called respondeat superior. But this is an exception. This injured employee's negligence is not attributed to the employer. He doesn't have to swallow that. He does have, of course, still to be responsible for all co-employees. Respondeat superior still does apply to them. Okay, final example. The employee is 50% negligent. The defendant's 40% negligent. The employer's 10% negligent. This is about as complex as it gets. Now, the employee being 50% negligent, 50% times 500,000, 250. That's where we start. We determine the employer's threshold. Again, it's 10%. 10% of 500,000 is 50. His threshold is $50,000. Now, what that means is the employer gets his 50. The employee gets 150 because it's 250 minus all of the workers' comp benefits, as usual. The defendant pays 200. Hope that's simple enough. If you have a problem, you can read it off the screen and figure it out. Now, we've talked about workers' compensation and subrogation in the sense of getting money back. But there's something else I want to talk about that's equally important, and that's what are called credit rights. Because in addition to getting money back that you've already paid out, you have the right to not pay, if you will, monies which you would otherwise owe. That offset is called a credit. And in any case in which, at the time the third-party case settles, there's still a workers' compensation case open and still benefits to pay, those credit rights can be absolutely critical. Let me give you an example of a situation that poses this. Let's go back to our earlier example. Our employee has a $500,000 value case. There's no comparative negligence on the employee, so technically he gets it all. But we're going to change the facts just a little. Not only has our employer paid $100,000 in workers' compensation benefits, but he's got $150,000 more still out there to pay. Okay? And because we're not up to the trial yet, we're not quite sure what the employer's negligence is going to be. If the employer walks away from this case, doesn't do anything, it's likely to be 50-50. Half on him, half on the employer. But if the employer gets involved in the case, maybe he can hold that down. Maybe he can push it down as far as, oh, say, 20%. Is it worth doing? Well, think about it. Best case scenario, 20% negligence. Your attorney's done a great job. Well, 20% of $500,000 is still $100,000. That means that after all of the work, after all of the trial, you've got a $100,000 threshold. You've paid $100,000. That means that the amount of money you're going to get out of this case is zero. Quick show of hands, folks. How many of you folks are going to hire an attorney to collect you zero? My guess is the answer is nobody. And if the focus of your subrogation effort is solely the recovery of money you've already paid, this is a case you're going to walk away from. But you shouldn't. Let me explain why. That threshold we've been talking about, that $100,000 threshold in this case, not only determines when you can recover money, it determines when you have to keep paying money. Because since your $100,000 threshold is exactly equal to what you've paid already, that means that the $100,001st dollar is subject to that employee's credit. The employee, after all, recovered $500,000 or $400,000 after your $100,000 is taken out. That means that he actually got a net recovery after he paid his attorney's fees and his costs somewhere north of $200,000. And your workers' comp claim was only worth about $150,000, remember? So you just established credit rights in that case worth $150,000, even though you didn't recover a dime. Ask yourself, for $150,000 to close off that case, would that be a good reason to file that action? I think probably the answer is sure enough. Now, often the most valuable thing you can do with a credit right isn't apply it directly at all. It's to settle the compensation case and the civil case at the same time using what's called a third-party compromise and release. Now, I'm sure you're all familiar with compromises and releases. We settle cases in workers' compensation using those all the time. And functionally, a third-party compromise and release is exactly the same. The only difference is that the money that's used to pay the employee for that compromise and release comes from the third-party defendant. Now, the reason that works is because you're going to agree to let that employee keep a little more money. That is to say, you're not going to recover all your subrogatable rights. Instead of recovering all of them, maybe you'll recover some of them. Maybe in an extreme case, you'll waive them entirely. And the employee, faced with the prospect either of getting workers' compensation benefits somewhere down the road or getting a big check today, has a huge incentive to say, sure, I'll do that. And you know who's got an even bigger huge incentive? His attorney. Remember, in the workers' comp case, that attorney is going to collect a 15% attorney fee. But if he settles the same case for the same money in the third-party side, his attorney's fee is going to be 30 or 40 or 50%. Now, the attorney, of course, will say, I never allow that to influence my decision. And you can believe that if you want. Beyond that, the second element that's important here goes back to these credit rights, and that is You can say to the employee in the course of negotiating for this third-party compromise and release, look, Jack, you're going to get money out of this case yourself, right? Well, every dollar you get out of that case is a credit against what we have to pay you next, which means your case isn't really worth very much. Think about it. An applicant who would happily have gone on paying, happily gone on getting medical benefits forever, going to his chiropractor, going to his acupuncturist, going to whomever, and letting you pay for it, is going to think twice before he writes that check himself, and that's what credit right means he has to do. In order for him to get past your credit right, he's actually got to incur that service, he's got to pay for it, he's got to save the bills, he's got to present them to you and say, see, I've now paid enough money to eat up all that credit. You know how many claimants are going to do that? Practically none of them. Now, what's important to understand here is how broad this is, because some people don't always get this. A third-party credit right covers practically everything. It covers temporary disability and permanent disability and medical obligations, every bit of the compensation you owe the employer, your employee. And it doesn't matter when it's incurred. This could be a bill that comes due tomorrow, or it could be a bill that's sitting on your desk that was incurred yesterday or the day before. So long as you haven't paid it already, it's still owed. It also covers, by the way, attorney's fees and costs. That's right. If the applicant's attorney thinks he's going to get a fee and you've got a credit right, he's just out of luck. The only things it doesn't cover, two things. It doesn't cover serious and woeful benefits, and it doesn't cover 132A obligations. But except for that, everything's fair game. Now, finally, and this is the best thing there is about credit rights, I have to say, it's what you can do with them against lien claimants. Let me give you a quick example. Let's say you got $50,000 worth of lien claimant claims out there. And they're all $5,000, $10,000 a piece. And after your third-party case settles, you got a $20,000 credit. Well, if you think about it, you might say to yourself, okay, well, I got $20,000 in credits and $50,000 worth of credit bills. So I guess I take $20,000 off and I pay the other $30,000, right? Wrong. What you do instead is you send a letter out to each one of those creditors saying, you've got a $5,000 or a $10,000 bill. I've got a $20,000 credit. Have a nice day. The reason for that is that each one of those creditors, after all, has to file his claim individually and prosecute it individually and get his judgment individually. And which one of those guys is going to go through all that effort so he doesn't get a nickel just so the next guy in line has a better shot at getting his bill paid? The answer? Nobody. Which means that even if you've got a relatively modest credit, so long as the credit is bigger than any of the individual bills, you can often make all of them go away. Okay, last thing I want to talk about before we're done, and that is how you go about perfecting your credit rights, because here there's a certain amount of confusion. If you've got a credit right, that is to say you've got a judgment or a third-party CNR or something that gives you credit rights, how do you go about making use of them? There has been a belief that you can just start stopping payments. You just, oh, I got this credit right, no more payments. There is some old case law that says you can do that, but it's a bad idea, and later decisions have superseded it. The only safe way to perfect your credit rights is to file a petition with the Workers' Compensation Appeals Board and get an order of credit. Now, there is some case law, I will say, which says that if your potential credit, that is the credit you have before you get the order, is hugely bigger than your potential liability, significantly larger, then maybe you can just stop paying and file your petition. But if there's any question about the adequacy, you've got to file a petition first. This is penalty time, folks, if you don't do it. So you want to be careful about that. And, believe it or not, that's about everything I have to say.
Thank you so much. Have a great day, everyone.